25. Both, my lords, Mr. Vikram and me are appearing in that matter, my lords.
For one person.
Yes.
Okay.
Why?
Mr. Sandesh will make some problem is
Because of the eye. ಅದು ಆಗ್ಲೇ ಮಾಡ್ಬೋದು ಆಯ್ತು ಅಲ್ಲ ಅಲ್ಲಿಗೆ.
My lords, I'll broadly point out, my lords, the three contentions that I'm going to be canvassing.
Yes.
My lords, what we are seeking is not just the quashment of this summons which is issued under 50, but what our prayer is for quashment of the entire proceedings which the ED has initiated. I will substantiate as to why we have made that prayer, my lords.
Your prayer is that?
Yes, my lords, my prayer is that. Now, my lords, 3 points, my lords, main points that I'm contending on. My lords, as on the date of initiation of the ECIR proceedings or proceedings under the PMLA, there exists no proceeds of crime. This will be my first contention. As I'll point out from the sequence of what has happened, there exists no proceeds of crime. There can't be an initiation of proceedings under the PMLA. Secondly, my lords, would it be permissible to permit an investigation which is at its infant stage when the ECI was registered? Would it be permissible to permit an inquiry under the PMLA happening parallel to an investigation to the predicate offense? This would be point number 2, my lords. As I will point out, my lords, generally, my lords, when we say the predicate offense should establish that there is a proceeds of crime from a schedule offense. Only then, my lords, the cause of action arises under the PMLA Act. Here, my lords, in my respectful submission, when a FIR is registered, within 4 days, if an ECIR is going to be registered and they put it on writing that they are inquiring into the very same allegation which is being investigated in the predicate offense, would it be permissible? This would be point number 2, my lords. And the third point, my lords, in view of the quashment of the proceedings, insofar as the then commissioner of MUDA, against whom the allegation was, it is he who has allotted this 14 sites, then, my lords, what would be the effect of me being the recipient of that 14 sites?
Beneficiary.
Beneficiary, me being the beneficiary, when, my lords, the proceedings against the person who has allotted has been quashed, what would be the effect therein? This would be the third aspect of it. These 3 contentions, my lords, are my broad contentions. Now, incidentally, my lords, when touching upon these 3 contentions, my lords, we will also be covering with what amounts to a proceed to crime. What's a proceed of crime? I will be touching upon that, my lords. And when does ED get jurisdiction, my lords? One of the aspects raised is on the jurisdictional aspect of when they get jurisdiction to even register an ECIR, my lords. Then, my lords, what would be the effect of section 107 of the BNSS to an PMLA proceeding? Now, this, my lords, assumes some importance because 107, my lords, under the BNSS was not there in the corresponding CRPC, my lords. Now, 107 specifically deals with proceeds of the crime. It gives a power of attachment. It gives the power to forfeit. Now, with 107 of BNSS being introduced, what would happen to the proceedings under PMLA? Whether, my lords, when the investigating officer to a predicate offense senses there is a proceeds to crime, he can attach it. He places it before the court. The court later has the power to forfeit it. Then, my lords, under section 5 to 8, attachment under PMLA, what would be the interplay between these 2 provisions? Something, my lords, which we have not had any judgment on.
Yes.
It is going to be for the first time. Now, my lords, to substantiate this, the third aspect which I just pointed out, my lords, the effect of the order passed by the coordinate bench in quashing the proceedings, what would be its effect insofar as the present summons is concerned? My lords was pleased to see the order, my lords. If for a minute, my lord sees paragraph 8 of that order, the 4 points that was considered by the coordinate bench, my lords, it said, page 13, the issues, my lords may notice the issues. The first issue, whether the authorization issued to conduct the impugned search and seizure at the residence of the petitioner on 28/10 and 29/10 and the consequent statement recorded under section 17 suffers from lack of jurisdiction. My lords, the point which we made out here was that, my lords, under section 17, the authorization can be given only by the director and no one else other than the director, my lords. But however, the court would hold, even if it is a case of subdelegation, it is all right. So this issue is answered against us. The first issue, my lords. Second issue, whether the said impugned search and seizure and statement recorded is bad in law for lack of requisite reasons to believe under section 17(1) and therefore an abuse of process of law, court holds in our favor, my lords. It is these reasons to believe, my lords, as we see in the act, we get it in about 8 places, my lords, in this act, and that becomes the absolute basis to have proceedings under it, my lords. Everywhere we get it, except we see in section 50, my lords, there is no usage of the word reasons to believe. Otherwise, in all other sections, we get the reasons to believe. And Vijay Madan Lal, they say, my lords, it's very different to see reasons to believe from reasons to suspect. That's the differentiation, my lord. So you must have something very concrete if you want to initiate proceedings under the PMLA Act. The third aspect, my lords, whether the impugned summons notice issued under 50 and various statements recorded therein be sustainable under law. Court holds it is not sustainable in this case, in our favor. Fourth one, my lords, whether in the course of its administration and execution of PMLA, the attachment of property under section 5 of the Act must mandatorily precede the conduct of search and seizure under section 17. My lords, this is for this contention, my lords. What we had pointed out is the whole act PMLA is for protection of money laundering. Now, if it is an act for protection of money laundering, the first step to be taken under the act, my lords, in our respectful submission, was that as soon as you sense there's a proceeds of crime, you will start with section 5 of having an attachment of it. After 5, my lords, when the conferment happens in 8, my lords, 8 says, when you're confirming it, you issue a notice to the person from whom this proceeds of crime has been attached. As a reply to that, when you get it, and you assess that there is a crime created under section 3, that is where the process of this criminal action begins. Because PMLA has both actions to it, my lords. One is going to be attachment, other is going to be the offense under 3 and 2.
You mean to say the drill should be in this seriatim like this?
My lords, is what we had contended. But court said there may be instances where even without attachment, they may proceed. So this point number 4, my lords, here, court said instances are there where so it need not be that in under 5 you've done an attachment, you may start the process otherwise. This is how it has been held, my lords. And after what the court has discussed, my lords, in that case, what took place was, even before issuance of summons under 50, they first came to the house, did search and seizure. And in the search and seizure, they did not get anything. So what they would do is they would take my phone, my lords. And from my phone, they showed that as seizure.
What?
My phone.
Huh.
They seize my phone. That is shown as a seizure under section 17. My lords, what should be seized under 17 would be proceeds of crime. But here, since they didn't get anything from the house, my lords,
Phone ತಗೊಂಡಿದ್ದೀರಾ?
phone,
ಅದೇ that is what.
ಅದನ್ನ duplication ಮಾಡ್ಕೊಂಡು, that is what they had retained.
ಯಾವ್ದು ಐಫೋನ್?
Yeah,
ಮತ್ತೆ ಅದಕ್ಕೆ ಬರೋದು ಮತ್ತೆ ಇದು.
Lord, phone is a record. My lord,
anyway, this is what
section
happened.
2 phone is a record.
Phone is
So
not
we have seized
seized.
the record.
No, phone is not seized as a proceeds of crime. Phone
It
is
is seized as a record.
to see whether there are any records of proceeds of
So, my
crime.
lords, on a
Exactly.
suspicion,
And
if
this
you're going to
argument
be
was
doing,
not at all raised in that court.
on a suspicion, if you're going to be doing a section 17 search and seizure, my lords, then they.
No, you submit on that.
Yes.
I don't agree with your drill, seriatim drill at all. It is not that an attachment order should be passed, summons should be issued. It's not that the procedural drill is not that way. It can be done. It's a flexible thing, that's all right.
Issued under 50 and later there's an attachment.
No, there is no problem at all.
So this is where the court would not agree with the submissions, but the two aspects which the court agreed was this entire action taken by them is absolutely unfounded. Prima facie, there is no case made out under the PMLA Act. My lords, we saw paragraphs 25 and 26, which was read out, my lords. Very clearly they would hold, my lords. And then paragraph 54, My lords, 25, 26, my lords has it at page 35. My lords would have seen that portion.
ಈಗ ಸೀನಿಯರ್ ಓದಿದ್ರಲ್ಲ.
ಹೌದು 25, 26, 54 ಅಲ್ಲಿ please notice 54,
ಹಾ.
no prima facie case to establish showing an offense that has been committed under the PMLA Act. Now, we all stand on the same footing insofar as the proceedings are concerned. And the court had the benefit, my lords, of seeing through the records. And after seeing the records, court finds this was not a fit case for you to have initiated this process at all. Now, my lords, with this, insofar as the first and the second contention is concerned, my lords, I have prepared an index with synopsis, my lords.
ಅವ್ರು ಕೊಟ್ಟಿದ್ದೀರಾ? ಕಾಮತ್ ಸರ್, ಕಾಮತ್ ಸರ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಏಜ್ ಅವ್ರಿಗೆ.
Illa, we will give it now, my lords. We're giving the synopsis now.
Even a soft copy can be sent.
ಹಾ.
I'll send a soft copy. My lords, we have gone a little bit in depth on PMLA, my lords, right from its
Which will you
origin,
not
my
go
lords,
in depth?
times, right from its origin to see, my lords, what exactly do we mean by proceeds of crime and what is the object of this PMLA Act. Now, my lords, the very object of PMLA Act is to prevent laundering, my lords. Now, what is laundering, my lords? When we get gains out of a crime, we try to layer it and then bring it back into circulation as a legitimate income, it becomes laundering. I will point that out, my lords. My lords, please notice the index page itself, my lords, how under 14 categories for a minute, my lords.
14 categories. Yes. Hmm.
My lords, you notice the synopsis and list of dates, which is relevant for this case.
Hmm.
And then, my lords, the history and evolution of the PMLA Act. It started off with the treaties and organizations, my lords. My lords, what they felt initially was it all started because of the NDPS Act, my lords. The NDPS Act, the money which was got, what they called as dirty money, my lords, that was sought to be put into the system, circulated, and then portrayed as legitimate money. That was the object for which, my lords, they felt we need an act that will prevent this laundering of money. That was the object behind it, my lords. So that is the history. Then, my lords, the parliamentary debates. Now, the debates also, my lords, very clearly established, my lords, it was only for the purpose of